matter is otherwise ready.
Ready, but your lordship has passed the order that a second appeal is pending. After that disposal, this case will be heard. So that is the reason it was taken.
That second appeal is in which court now? As of now, it is in which court?
Earlier it was in some other.
Now it is in this court itself.
Yes, yes.
Find it out, please. Find out, we'll tag it
Yes,
and
ma'am.
hear it. As a stay नहीं चलता है.
1 o'clock.
इस कोर्ट में ऐसे stay नहीं चलता है.
Yes, ma'am. I am also ready.
Stay चाहिए तो बस तैयार हो जाइए.
I'll inform you for
और उसका स्टेटस पता करिए हमारे बेंच का है. इनको देंगे ना ये बता देंगे.
Yes, ma'am.
From the supplementary list, this case is 10:30 AM, item 1, second appeal 87 of 2009.
आपका जूनियर का है कल बहस कर रहा था. I asked him to get ready.
जी.
आप कैसे आ गए?
मतलब कल हमारा पैर मुझे गया था. I was unable to drive.
वो बहस कर रहा था.
हाँ.
बुलाइए इसको.
Yes. उनके फादर को देखिए.
उनके फादर
जी.
कौन है?
Mr. My junior, he is my junior, Mr. DT.25.09.2025, and he happens to be his son.
Okay.
Both father and son are practicing.
That's good.
I'm sorry, my lord, I could not attend.
बुलाइए इसको. कोई बात नहीं.
यानी उसी ग्राउंड पे तो बोले कि हाँ हमको हराएंगे तो उसको जिताना है, आपको नहीं जिताना है.
अरे बंदा कम से कम फाइल तो पड़ेगा ना.
But so we ended on exhibit 2, that is the relinquishment deed.
Yes.
That is of the year 1961. Not just before I place the judgment. Not in my humble submission, lords.
Exhibit 2.
Exhibit 2, that is 28/11/1961. That is the deed of relinquishment. But that has to be seen because Exhibit 5, which is Khatya, which shows illegal possession, is of the year 1975. Records my possession, illegal अवैध दखल का 1975. So 75 I do not qualify, I'm not 30 years because the suit is of 99.
So your sheet anchor is exhibit.
Exhibit 2, exact. Exhibit 2. I have checked my other depositions also. There is no particular mention of a year 1960 or 61. So if I succeed on Exhibit 2, I succeed.
That's
But before I proceed, Lord, even Lord, this is a case, it is only academic because I am the plaintiff in the suit. I am claiming that I am in possession, illegal possession on basis of Exhibit 2 or Exhibit 5, that is entry in Khatya, and I am claiming by virtue of adverse possession. So, Lord, even if I don't succeed, I cannot be dispossessed because there is no suit. There is no suit by the other side.
And there is no direction also.
No direction also. In fact, there is
My
a
only concern is whether your adverse possession could have been declared.
yes.
Simple. You are in possession.
Yes.
Simple.
Now, Lord, in this background, if your Lordship will kindly take Lord's to section 46. Lord, don't take. I am only arguing Lord, on this that if a let us suppose if in Exhibit 2 there was a permission of Deputy Commissioner, then my lords, that would not be a violation of section 46. Then my title would have accrued from that particular deed itself, that is in the year 1961 itself. Then there was no question of any adverse possession because of Deputy Commissioner's permission. Similarly, when there is no permission, then my lords, my possession becomes illegal. The document itself becomes hid by section 46. Then lords, what has happened by virtue of that document is I have been put in possession. Although that yes.
Our own entire concern is
Yes.
when a document is declared to be null and void,
Null and void.
so it cannot be used for anything,
Yes.
even for the purposes of saying that you were in possession.
Yes. So lords, I will cite judgments on that. But I am only trying to argue on this, that even if a person, let us say there is no document as such, even if I am in illegal possession without having any document, then also it can't be said that my possession will not be looked into because you are in illegal possession.
Your possession will be looked into because you are already in possession.
Yes, my possession would be
But
looked
whether
into.
it will translate into adverse possession is something which is required to be seen.
Adverse possession is not illegal possession or hostile possession.
From which date?
From which date? So
Yes.
date has to be seen.
Date.
Date has to be seen. That plain paragraph 10 is there. Plain paragraph 10 is
You have
there.
said that you are in you acquire adverse possession from 1961.
But I say that we are already in possession. Although in 1961 they have executed a deed of relinquishment, and even Exhibit 2 recites that they were never in possession.
We can't look at it.
No, Lord,
Legally we can't look at it.
no, I am only saying this because Lord, there are judgment which says that even in a title suit, without Deputy Commissioner being a party to that, and that is in violation of Section 46, then also the date of the compromise decree in that title suit, because that is also in violation of Section 46, can be looked into for the purpose of taking into consideration the point of possession.
You see, it is one thing to say it is an unregistered document can be looked into for collateral purposes.
Yes.
It is totally different from saying when the document itself is void ab initio.
Yes.
If the document is void ab initio, we have to treat as if it never existed.
It never existed.
Right from its inception, it is scrapped. And once it is scrapped right from inception,
Yes.
then under such circumstances, your possession on the basis of very same document, giving a date of possession from a particular date, cannot be it.
Lords, in my humble submission, Lords, that can be, there are judgments for that, Lords. And let me straight away come to this. But here, upload नहीं हुआ, लेकिन यहाँ कॉपी लाया हम बुक में,
अपलोड नहीं हुआ तो
मतलब ये जो अलग अलग ये है ना सुप्रीम टुडे और इसमें नहीं है.
उससे कोई मतलब
हाँ ना, हम इसलिए ये दिखा रहे हैं. I have the book with me.
रिट पिटीशन का जजमेंट आप दिखाएंगे.
रिट पिटीशन का जजमेंट इसलिए दिखा रहे हैं because that considers कि whether possession can be looked into or not. Because here also there are cases. Your Lordship is aware that Section 71 में क्या हो? कि Lords, there is a claim of restoration. The defense takes place.
जब हम लोग सेक्शन 71 का पिटीशन देखते हैं,
Yes.
what is the first document I look at?
First document is application.
That application,
Yes.
right?
Yes, application.
That application should necessarily disclose
Disclose the date of
the date
disposition.
of possession, the date of disposition,
Disposition.
and the mode of disposition.
Yes.
Right?
Yes.
If they acknowledge that date of disposition is this,
Yes.
the mode of disposition is this, then under such circumstances that goes against them completely because they acknowledge it. Right? So that is a different thing.
No. Lords, your Lordship will find in number of cases that date of disposition is never mentioned in the application itself. They say 5-10 साल पहले, because they have to
नहीं
get
नहीं
right.
ऐसे नहीं, क्या बोल रहे हैं आप?
हाँ Lords.
नहीं आपसे ज़्यादा देख लिए अब हम application, क्योंकि जब भी CNT एक्ट का केस हम किए हैं, the first document I look at, अभी आपका केस में
I know.
The first
the first
document I
document your
look at-
Lordship looks at is the application itself, because that is the
सारा कहानी
initiation.
वहीं पर है.
But Lords, let us assume this, Lords, that if in an application the date of disposition is say 5 to 10 years, कि 5-10 साल पहले dispossess हुए, इसीलिए हम अभी application दे रहे हैं. Note the defense is that in a title suit there is a compromise decree. The argument from the applicant is that it is in violation of Section 46. Therefore, it can't be looked into because it is in violation of Section 46. Now, let us see this judgment. May I place this? But let us see the facts first.
Yes.
At the present, writ petition has been filed for quashing and setting aside the order dated 25/8/2008 passed by Additional Collector Ranchi, respondent number 5, whereby the appeal filed by Manohar Lal Chaudhary, predecessor of the private respondent, being SAR case number 17/2, was partly allowed, setting aside the order of restoration dated 5/2/2008 passed by the Special Area Regulation Officer Ranchi under Section 71A of the CNT Act 1908. With respect to the land of private respondent, that is respondent number 8 to 10, appertaining to Khata number so and so, measuring an area of 8 decimals out of 12 decimals of Moda so and so. Further prayer has been made for quashing and setting aside the order dated 11/11/2016 passed by the Commissioner South Chhatanagpur in SAR division number so and so, upholding the order of SAR appeal. It is also prayed for confirming the order dated 5/2/2008 passed by Special Area Regulation Officer Ranchi, respondent number so and so in SAR. But SAR case was allowed in toto. In appeal, it was allowed, and in revision, the SR appellate order was confirmed. The restoration was rejected in part. The learned counsel for the petitioner submits that the nature of the land of the petitioner pertaining to khewat number itna, khata number itna, plot number itna, measuring an area of 12 decimals is recorded in Khatiyan as Bakas, Buyari, Mahtoi in the name of Hika Uram and others. And the petitioner is the legal heir of the recorded khewat. The private respondent came in possession of the said land in last 10-11 years by creating forged and frivolous documents. The petitioner filed a petition under section 71A of the CNT Act 1908 in the court of respondent number 6 against Manohar Lal Chaudhary, Prabhunath Singh and Pradeep Singh with respect to the said land, which was registered as SAR case number 934/2003. The respondent number 6 passed the order dated 5/2/2008 allowing the petitioner's application as well as directing the respondent number 7 Circle Officer Ranchi to restore the possession of the said land in favour of the petitioner. Aggrieved thereby, Manohar Lal Chaudhary filed an appeal before respondent number 5, which was registered as SAR appeal number 17 R. The appeal was disposed of by order dated 25/8/2005, partly setting aside the order of respondent number 6 with respect to restoration of the land belonging to Manohar Lal Chaudhary, measuring an area of 8 decimals of land out of 12 decimals, and the order of restoration with respect to 4 decimals of land belonging to Pradeep Singh and Prabhunath Singh was confirmed. The petitioner preferred revision before respondent number 3, which was registered as revision number 2 and 2. However, the same was dismissed, observing in the area that the proceeding under 71A of the was barred by limitation, and accordingly by order dated 25/8/2008 passed in by respondent number 5 and SAR appeal number was 2 and so was upheld. It is further submitted that the claim of private respondent, their predecessors over the said land since 1953, that too on basis of Sada Patta allegedly executed by Deva Uram, Mahali so and so, is illegal at Pakas Buyari Mehtoi land, is not transferable in nature, and which was donated by the villagers of the ancestors of the petitioner in view of the salary performed Mehtoi work. It is submitted by Manohar Lal Chaudhary that filed title suit number 1105 of 1967 against the ancestor of the petitioner, wherein a collusive decree was obtained by him on the basis of alleged compromise arrived between the parties on 29/1/1968. However, the petitioner or his family member ancestor had never signed any compromise petition. Moreover, the said title suit, the Deputy Commissioner Ranchi, despite being necessary party as the provisions of CNT 1908 was not arranged. Otherwise, also the said land, being Buyari Mehtoi in nature, had not vested in the state by virtue of provisions of Bihar Land Reforms Act 1950, and hence any rent receipt issued with respect to the said land has no legal sanctity. It is also contended that the authorities dealing with the case under restoration under 71A have no jurisdiction to restore such land belonging to members of scheduled tribes. The same has been transferred by playing fraud, including obtaining a collusive decree. Despite that, the appellate as well as the regional court have erroneously allowed the appeal and the revision in favour of Manohar Lal Chaudhary. It is further submitted that the said land was allotted to the village Pahan by the villagers to perform rituals of village deity, and thus the same was inalienable, non-transferable either by the recorded Khewatdar or his legal heir to any person. On the contrary, the counsel for the respondent state submits that the revisional authority has rightly observed that the application filed by the petitioner for restoration of the said land invoking section 71A after lapse of 35 years from disposition. Moreover, there is no perversity or illegality in the order of the appellate as well as revisional authority so as to warrant any interference under Article 227. Third, para 9 and 10. Thrust of the argument of learned counsel for the petitioner is that the nature of the land belonging to the recorded Khewat holder as Pakas Buyari Mehtoi, which was non-transferable, and Manohar Lal Chaudhary acquired the said land by playing fraud with the ancestor of the petitioner, and as such, the respondent number 6 had rightly passed the order of restoration of the said land under section 71A of the Act 1908 in favour of the petitioner. It is further argued that the revisional authority has affirmed the order of the appellate authority on mere ground that the application of restoration of the land has been preferred after lapse of 35 years, ignoring the legal provision that there is no limitation provided for filing restoration case under 71A of the CNT Act 1908, and on this score alone the order passed by revisional authority is liable to be settled. It is evident that from the record, the title suit number was filed by Manohar Lal Chaudhary against the ancestor of the petitioner, and the said suit was declared in favour of Manohar Lal Chaudhary in the year 1968 on basis of compromise arrived between the parties. Even if the said decree is assumed to be collusive one, the same proves possession of the private respondents. their predecessor interest in 1968, which has not been specifically controverted by the petitioner, bringing on record any cogent evidence. So this floats that the court observes that, and even if it is assumed to be a collusive decree, then also possession can be taken note of from this date. Now, notice, this is one judgment, but the second judgment is
Just a moment.
yes. Because here also, notice the court considers that 35 years from the date of decree, compromise decree, and therefore ultimately holds that it is barred by limitation, taking into view that and the writ petition was
लेके
dismissed.
आइए तो 2003 का 7 SSC 667.
Bill number 6.
2003 7 SSC 667. दूसरा चाहिए 2000 Volume 5 SSC 141.
But 2005 is Jaimangal law.
Yes.
Yes. But another judgment
So
is
Jaimangal Urao is 2000 Volume 5.
yes, 2000. But the court considers three judgments, but basically. Jaimangal law, Situ Sahu, and in Situ Sahu only there is a reference of 2003 7 SC.
ऐसे selectively reference नहीं देते.
हाँ हम वो judgment take. So Lordship may kindly take another judgment.
Just a moment. ये वाला जजमेंट देख लीजिए. इसमें कोई एंट्री फाइल है. WPC नंबर 2833 of 2021.
Pass on another judgment. Because this has been challenged in LPA, it has been confirmed. This one. This I know personally because I have argued this matter. Then notes the restoration application was filed. Initially the same was rejected, and then in appeal and revision notes the restoration was allowed. The writ petition was
ये जितने भी judgments हैं, it
Yes.
starts from Jaimangal Urao.
sorry.
It's to sequence of judgments
Yes.
on 71A.
Yes.
It starts from Jaimangal Urao, first one. Which is the
Jaimangal
first
Rao
judgment.
और जयमंगल राव की
Sequence बताइए.
हाँ
क्योंकि बाकी सब तो follow किए.
हाँ बाकी सब फॉलो
हाँ तो आप उनको वो जो sequence है वो बताइए किताब में.
yes. But the first judgment on this is Jaimangal Rao.
First is Jaimangal Urao.
First is
Citation
Jaimangal
बताइए.
Rao. Yes.
इनका citation note करते.
2000 volume 5 SCC page 141.
1000 volume 5 SSC 141.
141. Then was Situ Sahu. This is 2004 8 SCC
2004 8
8
SSC
SCC 340.
340.
Yes. After this notes Kulchan Munda for exact citation I'm not having right now. Taking PC with the reference.
LP file में क्या होता है? Order में.
Can I please note this?
Just a moment. तीसरा नंबर कौन सा बताया?
For Kulchan Munda.
फुल चल.
That is also Supreme Court. This is perhaps 2008 something.
14 SCC 774. Approval disposal. This has not attained finality of first judgment. That is pending.
But it is a single judgment which has not been stayed or
We are in
reversed.
second appeal.
Yes,
We
yes.
will decide the law.
Yes, yes.
A law, a question of law will be decided, which will bind everybody.
But I will also refer to Situ Saw on this because Situ Saw also considers this aspect. About
So where is that judgment?
yes, yes.
Give me those judgments. It's
Ah,
very
I'm lying, Lord. I've brought a copy for your Lord. But kindly take this second judgment. This is 2020 JCR 258. Sunil Kumar Jaiswal was the state. Yes. But may I place the entire or should I place the relevant?
Fact के बिना कोई judgment नहीं.
Ah, ठीक. The writ petition has been filed for quashing order dated 8
Your paragraph में आएगी factual background.
Factual background. The factual background of the case as stated in the writ petition is that respondent number 529 filed an application for the restoration of land appertaining to khata number so and so measuring itna of CMT. The petitioner and his three uncles appeared before special SAR officer Ranchi and raised the issue of maintainability of the said restoration case by filing a petition contending that previously also SAR case number itna was filed by special officer area regulation same by Pancham Urao grandson of recorded Rayya Sanichar Urao.
Let's take it this way.
Yes.
I just pose a question. In all these cases which you have cited,
Yes.
scheduled area regulation has not been considered. Correct?
Scheduled area regulation.
1969, that amendment.
30 years.
No. 71 says at any time,
Yes, at any time.
and court says beyond reasonable doubt.
Yes.
Right? None of the judgments,
Yes.
as I remember, I have read it full text.
Yes.
Right? Schedule area regulation, that amendment to section to the Limitation Act has not been considered. अब चेक कर लीजिए. ऐसा हमको जहाँ तक हमको ध्यान है नहीं कंसिडर हुआ इसी में.
But Situ Saw considers that.
Schedule area regulation.
Yes.
How
Situ
does it
Saw.
consider? What does it say?
But Situ Saw can it just pass on the judgment? Yes.
You have a copy for you?
Yes. But whatever I place note that I definitely
it's-
make it a point that I give.
Let us see the facts.
Yes.
Let us see the facts.
Yes. But paragraph 2 may I place?
Yes.
Yes. The area to which CNT Act 1908 applied certain lands were originally recorded in the name of Kocha Urao, Pachu Urao, so and so, ancestor of Bundia Urao, of one Bundia Urao. They were recorded tenants of lands of Khata number 13 of village Kota Nagpur. Jagna Urao died immediately after the original survey. Kocha and Pachu surrendered the tenancy pertaining to plot number itna, measuring an area itna land to the landlord, the Maharaja of Kota Nagpur, by a registered deed dated 7/2/1938. Soon thereafter, landlord settled the land to the appellant on 25/2/1938. The appellant has been in possession of the land and cultivating it. On 3/2/1978, the Saint Budia Urao filed an application under section 71A of the Act for restoration of the land in question on the ground that the appellant had fraudulently acquired the land by means of Sada Hukumnama. This application was registered as SAR case number so and so. The special officer Ranchi issued notice to the appellant, and after hearing the parties and recording evidence, came to the conclusion that the land belonging to the ancestor Bundia, who was member of scheduled tribe and Katyani holder of the land in question. Although originally there was 4 co-sharers in lands, namely Kochia Urao, so and so, so and so. The tenancies were surrendered only by Kochia and Bachua and not by other two. The surrender was made on 7/2/38 and the settlement in favor of the appellant was made on 25/2/38. The special officer took a view that the surrender and settlement of the land constituted one continuing act and was therefore contrary to the provisions of the act. He also held that the surrender was illegal as all the shareholders had not surrendered their rights and decided that by the reason of the provisions of section 71A of the Act, the tribals would not have been dispossessed from the aforesaid land in view of that matter. He allowed the application for restoration of possession to the applicant only of law, and by order dated 9/5/80, the appellant appealed to additional collector Rafi, who affirmed the view of special officer. The revision was also dismissed, upholding the two views. The appellant challenged the order by the revenue authorities by filing a writ petition before Patna High Court. The High Court dismissed the writ petition, holding that 71A of the Act is a beneficial legislation and the legislative intent is to extend protection to a class of citizens who were unable to protect their properties on account of backwardness, and therefore the court had to give a broad and liberal construction to the legislative intent of protection. The High Court agreed with the authorities below that the surrender of the tenancy and the settlement of the land coming in quick succession was continuous transaction was hit by section 71A of the CST Act. The contention that the application for restoration was filed after the period of limitation was rejected on the grounds that plea of limitation has not been raised at any stage of the proceedings. On this reasoning, the High Court dismissed the writ petition, hence before the appeal. Before we take up contention in this appeal, a quick look to the applicable material legal provisions. CLT Act 1908 of 1908 is vintage by amending Act 1947, which came into force with effect from 5/1/48. Section 46 was introduced in the statute. Section 46 of the Act puts a restriction on transfer of rights by a Rayat who is a member of scheduled tribe. As a rule, any transfer of holding or portion of his holding by sale, exchange, gift, or will, or so on, is prohibited by Section 46. Proviso A and B of Section 46 deals with transfer of occupancy right by a Rayat who is a member of scheduled tribe. Both these provisions contain only exceptional situations under which transfer of an occupancy Rayat of a Rayat who belonging to a scheduled tribe is recognized in law, and that is why it has been done with the previous sanction of the Deputy Commissioner. By a further amendment by Bihar Scheduled Area Regulation 1969, certain amendments were made inter alia in Rule 3 of Order 1 of Code of Civil Procedure, Article 65 of the Second Schedule of Limitation Act 1963. What is important for us is the introduction of 71A and 71B in Futanako tenancy so and so. If not 71 is quoted, we can skip that. The section has three provisions which do not concern so far as the present appeal is concerned. The important point is to be noticed that Article 65 of the Schedule of the Limitation Act of 1963 was amended simultaneously by providing a period of 30 years as the limitation for bringing the suit for recovery of immovable property belonging to a member of scheduled tribe. Against the background of the legal provision, the Learned Counsel for the appellant raised the following contentions. First, 71A has no application whatsoever to the case of appellant, even if surrender of tenancy by the tenant on 7/2/38 followed by settlement of a property on the present appellant on 25/2/1938 could be considered as transfer within the meaning of section 71A. There was no provision of law which existed in the year 1938 under which such a transfer was prohibited. There is no retrospective effect given to section 71A so as to cover transactions which took place in the remote past. Hence, the power to restore possession could not have been exercised. In any event, period of limitation 30 years was long past when the application for restoration of possession was sought to be entered by the special officer in the year 1978. Despite service of notice of this appeal, there was no appearance by the 5th and 6th respondent who are contesting respondents. Hence, we requested Mr. P.S. Nasimba, the counsel, to appear as amicus curiae and represent the interest of the said respondent who belong to scheduled tribe. Mr. Nasimba has commendably represented the case of the said respondent and brought to our notice some of the judgment in this having
You
a
read
bearing
paragraph 12.
paragraph. Yes, I also marked notes paragraph. Yes.
That's important.
Yes, that is very important because the second argument is very important for me. Yes. Mr. Nasimba fairly conceded that he was not in a position to demonstrate that surrender which took place on 7/2/38 was in contravention of any
So
of the-
therefore,
Yes.
that surrender could have been taken as a date of disposition.
No.
Otherwise, also
Yes.
that particular date,
Yes.
right, the surrender and settlement,
Yes.
right, that was an admitted fact, and there was no plea of fraud pleaded against in connection with that. There are two links of it.
Yes.
And that arises because of the reason that the judgment which the Honorable Supreme Court has followed
Yes.
has itself recorded that in case of any absence of pleading of fraud or collusion, it cannot be so moto taken care of by the.
So here also, my lord, so far as regime 2 is concerned, there is no traverse to that. Lord, kindly see, Lord, I want to just show to your Lordship, Lord, para 14 also. because look, first para 12 your lordship has seen,
Just a
he
moment. You are the plaintiff.
and the plaintiff.
Just a moment. It has been clearly alleged to be fraud, to be para 18.
Note me see notes paragraph 10 of my plate.
Yes,
First.
I've seen your para 10 and para 18.
Para
The written
10
statement.
and paragraph note
18 of the written statement.
yes, para 18. Note it is a registered relinquishment. Note let
We
us
will not go by that.
no note the lordship
It has, they have alleged fraud, right? Read it, please.
yes. What it says, note that in reply to para 10 of the plaint, the statement are not correct and denied. Jagat Mahto alias Jagat Narayan Bhagat, son of Sadev Bhagat, have never executed any deed in favor of plaintiff within his knowledge. Despite of that, if the plaintiffs are in possession of any deed, the same is illegal, in contravention of section 46 and void. The plaintiff shall not get any title by virtue of void. So they say basically that it is not within my knowledge. First, they say that even if there is a deed, it is in violation of section 46. They have not pleaded that it is fraud. They say two things: not within my knowledge.
No, not within my knowledge means he did not execute.
But it is a registered document. There is a presumption. It is a registered document. By saying that I don't know, can a registered document be said to be vitiated by fraud? It can't be fraud. They have to come forward with a specific pleading of fraud. It can't be. They only say this, that it is not within my knowledge, and even if it has been executed, it is in violation of section 46. That is what they say in denial. So therefore, there is no case of fraud alleged with that document. Note, your lordship may kindly take note at C2 South judgment note, because I want to just show to your lordship what the Supreme Court also considers. And it just notes conclude paragraph 12 notes second part of the argument notes.
Yes.
So note 38 deed, there was no section 46. He, however, strongly urged that the circumstances of the transfer brought about on record suggest a fraudulent transaction on part of the landlord. He particularly urged that the facts will show only some of the co-sharers had surrendered their rights, while some had not, and the landlord had managed to take possession of the land and within the span of less than 3 weeks settle the land upon the present appellant. This transaction smacks of a fraudulent act and must be viewed as in his submission. Now, note para 14. We shall now examine the last argument of Mr. Nasim, that the transfer was fraudulent. Even on this, we are afraid that the appellants are entitled to succeed. We need not go into the details of the transaction, for we may even assume that the transfer was fraudulent. Even then, as held in so and so, the power under section 71A could have been exercised only within a reasonable time. So even though a fraudulent transfer is there, the Supreme Court also says that a reasonable time has to be looked into. And that reasonable time is not 30 years in terms of that.
Complete reading, please.
Yes. Looking to the facts and circumstances of the present appeal, we are not satisfied that the special officer exercised his powers under section 71A within a reasonable period of time. The lapse of 40 years is certainly not a reasonable time for exercise of power, even if it is not held with May I please?
Yes, yes. I read it.
Oh.
But more fast.
Oh, once your lordship has read it, not the Supreme Court allowed the appellate contention and dismissed all the restoration application. Not so far as this Sunil Jaiswal case is concerned.
Just a minute.
Yes.
Jagat Mehto is a party here.
Jagat Mehto.
Ram Mehto and Lachu Mehto are party here.
They are not party member in this appeal.
Then
They are not party member.
Ram Mehto, Ram Rao and Lakshu Rao
Yes.
have been shown to be in illegal possession since 1975.
1975.
Ram Mehto and Lakshu Mehto are one and the same person. Ram Mehto and Lakshu Mehto. Because it is Ram Mehto and Lakshu Mehto who had executed the. Just a moment. And the person who had executed the relinquishment deed,
Yes.
Salva Mehto, his two sons are Ram Mehto and Lakshu Mehto.
But para 11 your lordship.
Yes, yes.
Salva Mehto, son of Bandhu Mehto, holders of RS Kevas number so and so, died leaving behind Rama Mehto, alias Rama Udam, and Lakshu Mehto, as
Yes.
is legal.
Para number?
Para 11 of the print.
Para 11 of the
Yes.
So, and what is the reply to para 11? Admitted.
It is admitted.
So, Ram Mehto, you are claiming possession in your record of right. The possession is recorded since 1975.
Yes.
And whose possession is recorded? Whose possession is recorded? Ram Mehto and Lakshu Mehto. They Ram Rao and Lakshu Rao. Yes, who are the plaintiffs? उन्हीं का possession recorded.
Yes, so I say not 1975 I can't succeed because 30 years I can't fulfill. So I have to go back to Exhibit 2.
But
Yes.
the predecessor of interest of Ram Mehta and Lakshu Mehta,
Yes.
right, had executed the relinquishment.
Relinquishment deed.
So
Yes.
if you want to rely upon the relinquishment deed,
Yes.
then under such circumstances, he is the person who has executed the relinquishment deed, Ram Mehta and Lakshu Mehta.
लॉर्डशिप से जस्ट सलवा
ये सलवा महतो इन्हीं के दोनों बच्चे हैं ना?
हाँ इन्हीं के दोनों बच्चे हैं
हाँ।
पैरा 11 में
हाँ। पैरा 11 में इन्हीं के दोनों बच्चे हैं।
हाँ
Yes. You are the plaintiffs.
but exhibit 2 is by जगत नारायण सहदेव के बच्चे exhibit 2 is by जगत नारायण one सहदेव
But that's
that
right.
is from the defendants.
You tell us,
Yes.
exhibit 2, who
Yes.
surrendered to whom? First party, second party मत देखिए, who surrendered to whom?
हाँ।
Exhibit 2.
जगत नारायण surrendered. He is son of Sahadev Mahto,
Yes,
the ancestor of these defendants,
yes.
in favor of Rama Mahto.
नहीं, सहदेव,
हाँ वही इनका पैराग्राफ ये लिखा है ना प्लेंट का W का पैराग्राफ 9 उसमें एक जिनोलॉजी दी है कि ये किसके थ्रू क्लेम कर रहे हैं ये बोलते हैं हथिया महतो के दो बेटे हैं सहदेव और पीठिया
ये आप उनको exhibit 2 बताइए,
Yes.
ठीक है? कौन किसको surrender कर? Who is surrendering whom?
ये हम लोग जगत नारायण वल सहदेव महतो रामा महतो और लद्दू महतो
Just a minute.
जगत नारायण
महतो,
जगत नारायण भगत वल सहदेव भगत और इलियस महतो
ये देखिए पैरा 10 में जो आपका केस है,
Yes.
जगत महतो son of सहदेव में,
Yes. After death of
Surrendered.
Sahadev, only son Jagat executed a register. Yes, correct.
surrendered. This is 28/11/61.
Yes.
Exhibit 2 in favor of plaintiffs.
Relatives.
The plaintiffs were Shankar Oraon,
ये प्लेंटिफ है लोग शंकर और रामा में तो का बच्चा है
son of Padna Oraon,
शंकर उराव सन ऑफ लेट रामा उराव जो है जिसके नाम से सरेंडर हुआ है
Lakshu Oraon and इनके बच्चे.
हाँ दोनों का नाम से हुआ लोग रामा महतो हुआ लच्छू महतो तो प्लेंटिफ नंबर 1 2 रामा के बेटे हुए 3 4 जो है लच्छू के बेटे हुए
Plaintiff number 1, Shankar Oraon is not
शंकर उराव इज सन ऑफ
Padna Oraon.
पन्ना
Who is Padna?
कीर्तन होगा तो रामा होगा इसके नाम सरेंडर तो फिर राम विलास बुलाओ है लच्छू का और सालू बुलाओ है लच्छू और बट एनीवेज नोट जो भी प्लेंटिफ है उनके फेवर में रिलिंक्विशमेंट हुआ from their side, it is admitted. So far as what we have seen, Exhibit 2 also.
और illegal possession किसका दिखाया गया?
Illegal
रामा
possession,
ओराव and लक्ष्य.
लच्छू, जो मेरे मतलब plaintiffs के father. So that will not help, Lord. 1975 illegal possession, how will I succeed on that case? So only base of my case is Exhibit 2. And I cite one more judgment note which I have just passed on, Lord. I want to just show, Lord, this also considers that titles would collusive and then possession. And it has been confirmed in LPO.
Which judgment?
But that 2022 JCR 258, Sunil Kumar Jaiswal, 2020 volume 2 JCR.
That's right.
Can we skip the fact note?
Yes.
Yes. Not
I
paragraph 4, your lordship may see, because this was the contention. Because not here, not initially restoration application was rejected, appeal not restoration was allowed, revision restoration was confirmed, writ court not set aside, the appellate and revision
The
not.
possession was since 1947.
Yes, it was alleged in the title suit decree that possession is since 1947. Although it was not, we were contesting on two grounds. First is res judicata, and second, there was a compromise decree which records my possession. So there were 2 points. So let us see paragraph 4. What was the argument of the other side? Because that will clarify notes. May I please note paragraph 4. Per contra, the learned counsel for respondent 5 to 9 submits that the petitioner, predecessor in interest, by suppressing the real fact, succeeded in obtaining a collusive decree in title suit number 131 of 60 against the predecessor in interest of the private respondent and dispossessed them from the suit land by fraudulent means, and as such there has been violation of provisions contained in section 46 of CNT Act. This was one of the contentions. Now Lord, other paragraphs are relating to res judicata. Now Lord, kindly take Lord paragraph 11 onwards. Para 11, no? Where the court considers C2 sound judgment,
Yes.
which we just read.
Yes.
So we can skip that note. Because paragraph 14 of C2 sound, that even if it is fraudulent, it can be looked into, has been taken note of. And then note paragraph 15.
This is a substantial structure.
No, just after 1969 word note.
Yes, even
Assuming that the order passed in the said title suit should be treated to be collusive in nature, and title did not pass on the petitioner by such order, the long possession of the petitioner over the said land cannot be denied, and in such situation the present restoration application can be said to have been filed after unreasonable delay. And therefore note, all the restoration orders were set aside and it was confirmed in LPA. LPA notes, I could not get the order copy, note LPA is 288 of 2022.
288 or 20.
22.
It's already done. LPA must have been dismissed.
It has been dismissed. I was appearing there also. 288 of 2022.
288 or 22.
But so, in sum and substance, my argument, so far as violation is concerned, section 46, but on face of it, I cannot justify that it is not in violation. I agree that it is in violation of section 46, but still I say, but title will not pass on to me by a document which is in violation of section 46, but possession can be looked into, because even in a case of illegal possession also, when there is no document as such, then also if a document records illegal possession, then also not for purpose of, because adverse possession is what not? It is not ownership. It is possession in exclusion to the owner. That means I am not claiming ownership, title. I am claiming title only on basis of my possession. And it has now matured into my title by virtue of adverse possession. So even in a case, notes where I am in illegal possession or a document in collusive or it is in violation of section 46, the date of can be looked into for the purpose of deciding the possession point, and from that date if I succeed, not 1961, suit is 99, about 30 years I qualify. Now the appellate court have only said that because it is in violation of section 46, therefore have negated my claim. Page, internal page 11 notes. And then notes issue number 5 have been dealt with page number 12, para 8 onwards, and it says that there is no specific date or year. But in my humble submission, I would submit that once deed of relinquishment is there, which mentions a date, which mentions therein that from this date they were already in possession, from this date we do not have any claim, entire claim is with them. That is the cutoff date, 28/11/1961, and therefore it is non-consideration of Exhibit 2 in its correct perspective in deciding this.
Let us see the inclusion.
Yes.
Okay, but even is Did you also challenge the entry in record of right?
I am not challenging because there is no prayer in the plate.
Entry in record of right may not have any relevance to so far as title is concerned.
Yes.
But it will certainly have a relevance so far as possession is concerned.
But it only says illegal
Presumption.
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 Yes,
Nothing
presumption.
more.
Nothing more.
Nothing
So,
more. It is not a conclusive
it is not
piece of
a
evidence
yes,
at all.
exactly. But Shankar Udav जो है हम लोग देख रहे थे पिटिशन प्लेंटिफ नंबर 1, he is also son of Rama Mehto only. तो लगता है प्लेंट में ये क्योंकि एविडेंस में भी आया है इंस्ट्रक्शन के लिए वो रामा का ही बेटा है.
ठीक है.
ऐसा नहीं है कि किसी he has supported so far as relinquishment is concerned paragraph 8.
There is no allegation of collusion,
No, there is no allegation.
according to you.
There is no allegation
Let's
of
see the finding.
yes. And we straight away come towards paragraph 7, issue number 8.
Of appellate court.
Appellate court, because trial court is in my favor.
Paragraph 7.
Paragraph 7 notes, issue number 8,
That's
where exhibit 2 is considered. The deed of relinquishment, exhibit 2, is assailed on behalf of appellant mainly on the ground that it amounts to transfer since the permission of deputy commissioner has not been taken. So it will be hit by section 48(1) of CNT Act. Section 48 reads as under. We can skip this. It is held in so and so that the provisions section 46 are intended by the legislature to secure the tenants inhabiting the area their right in their occupancy holding. The policy of the Act is to be defeated by use of indigenous device, circumvent and pass the statutory protection provided under section 46. Therefore, the surrender of the land recorded by tenant without prior permission of deputy commissioner of the district as required under section 46 is invalid. The law therefore mandates that transfer without prior permission of deputy commissioner will be invalid. To counter this, it is argued on behalf of the respondent plaintiff that the deed of relinquishment did not effect any transfer but only acknowledge an existing state of affairs, that the land is being in possession. Therefore, the consent of deputy commissioner as a condition precedent was not required. On the other hand, it has been argued on behalf of the appellant that the deed of relinquishment to all intent and purpose was the deed of transfer executed in favor of the plaintiff Jagat Narayan by Jagat Narayan Mahato, whose line of inheritance became extinct to frustrate its devolution on the defendant, who were the closest agnates reliance have been placed on so and so. It was held that the deed of relinquishment was also a transfer, which is barred by section 46 of CNT Act without permission of deputy commissioner. At this juncture, it will be desirable to look at the genealogy of Hatia Mehto given by the defendant in the written statement, which is as under. The genealogy is not in dispute by the plaintiff. It is admitted position that Vishram Bhagat predeceased Jagat Narayan and lying close to at Parvatiya. Here the suit land is recorded in the name of Sadev Mahato, son of Hatia in CS and RS record of merit. By the execution of the deed of relinquishment, Jagat Narayan Mahato, the person to be immediately aggrieved was Parvatiya. She filed SAR case number 8. Now it is asserted that this case was rejected, but the order has not been adduced into evidence. only notice issued in this has been brought on the record as Exhibit 9. Nevertheless, since under Orang customary law, the right of female inheritance is not recognized, therefore the claim of Parvatiya for restoration of the land cannot be attached much importance. After the line of Sahadev Mato closed with Parvatiya Devi, the property was to devolve on the defendant in terms of Section 23 of CNT Act according to the Crown customary law. It was against this background that the plaintiff got a deed of relinquishment executed in their favor in contravention of Section 46 CNT to defeat the devolution of the property on the nearest stagnant. It becomes the moot point whether Parvatiya Devi succeeded in her SR or not. Under the circumstances and the reasons discussed above, I find that the deed of relinquishment was invalid under Section 46 of the Act and cannot be made the basis of title of the plaintiff. The issue is accordingly decided in favor of the defendant.
Parvatiya Devi, she filed an SR
case,
but those documents were not produced. Not executed.
Not executed. She filed an SR case against us. That was dismissed, but that document is not there. The notice is Exhibit 9.
Issue number 5.
Yes. But in order to succeed and prove title on basis of adverse possession, it must be adequate in continuity, exclusiveness, publicity, and with hostile assertion. It was held in so and so. Not, can you skip this?
That's right, yes.
Yes.
Firstly,
the plaintiff case is that they were all along in possession of short number 3/1. No specific date and year is disclosed since when they came into possession of the suit land and against whom. The claim of title by adverse possession can only succeed against the rightful holder of the title. The plaintiff have denied the title of the suit land of the ancestor of the defendant, and at the same time they claim that it by adverse possession. They have themselves claimed to be true holders. At the same time they claim it by adverse possession. Claim of title by inheritance and that by adverse possession are two inconsistently which cannot be taken. This is the basic infirmity. This Your Lordship is aware, but now a recent judgment have come that the plaintiff can also take a plea of adverse possession. Because initially it was only a shield, now it can be used as sword.
no, it is not saying that. It says that on first instance they are claiming title and simultaneously they are claiming.
Yes, inconsistent. Not if title fails.
Inconsistent is another thing.
Yes.
Whether plaintiff can take a plea of adverse possession.
So initially, the initial times, before that judgment of Supreme Court, it was only as a defense.
That's right.
Now, after the Supreme Court judgment,
A person can file a suit seeking adverse possession without claiming title.
Yes.
Title
without claiming title. But it is not a bar that we can't claim a title, and we also claim that by virtue of adverse possession. Because if my title claim fails, but if I have a case on adverse possession also, that can succeed. Here, if Exhibit 2, if I get a title on basis of that, then adverse possession will definitely fail.
The land was originally recorded in whose name?
Defendant's name.
In defendant's name.
Because that is the Khatiyan.
Then, secondly,
from when did the plaintiff enter into possession of the suit land? The assertion in paragraph 13 of the plaintiff is that the ancestors of the plaintiff were in possession since before the cadastral survey of 1912 and the divisional survey of 1934. Entries in the record of rights are not in their favor. A rebuttable presumption arises that the defendant ancestors were in possession of the suit land. No documentary evidence has been adduced to rebut this presumption. The only documentary evidence is the entry in the copy of the recent survey Khatiyan, number so and so corresponding to Itna, entered in the name of Musammat Parvatiya as tenuous holder, and in the remarks column, illegal possession of Rama Urao and Lachu Urao since 1975. Even this is accepted as evidence of possession since 1975. The statutory period of 30 years required under Article 65 of so and so Schedule 1969 is not completed at the time of filing of the suit in the year 1990. The other point is that the very pendency of the proceeding initiated in the year 89 under 144 CRPC, which was subsequently converted into 145, repeals the contention of the plaintiff on continuous and peaceful possession and assertion of hostile title against the defendant. The defense on their part have been adduced as Exhibit A, which is rent receipt Kevat number Itna issued in the name of Sahadev Bhagat on 24/6/2002. Exhibit C is the order of DCLR so and so, so and so. From perusal of this order, it transpires that the order passed in favor of applicant Sahadev Bhagat. This order was made in favor of defendant Sahadev Bhagat since it was Khatiyani land of Uttan Bhagat, and after abolition of Zamindari, registered to Khata number 81, entered in the name of Jagat Mehto. The genealogical table produced by Rama Mehto was not found to be correct. The deed of relinquishment, in absence of necessary permission of Deputy Commissioner, was not accepted, against which an appeal have been preferred by Rama Mehto in MS, in which by order that Litna Circle Officer was said. The matter finally went up before the Court of Commissioner in mutation revision number so and so preferred by Rama Mehto against Exhibit E, in which genealogy given by the petitioner was not accepted, and on the basis of the possession of land was directed to be mutated in favor of the party confirming the order of petitioner collector. It was also found that there has been fraud or collusion in revenue staff in getting the name of Rama Mehto entered in Jamabandi. The order of revenue courts has been assailed by the respondent plaintiff that since Buyeri land was not an occupancy right and does not come within the definition of tenure under section 223 Land Reforms Act, and the revenue is not paid to the government, therefore mutation is without jurisdiction. Lands have been placed in so and so. It is true that Buyeri land is a privileged tenure land which is revenue, in which the revenue is not paid but cess is paid to the government, but the mutation for the purpose of collection cess is no where barred. In the result, the entries in the record of right of the cadastral survey and revision survey and mutation orders are strong documentary evidence of possession. The recent survey entry does not indicate illegal possession of 1975 since 9. But this by itself does not complete the statutory period required for adverse possession. On the face of this documentary evidence and oral evidence cannot be attached much importance, since both the evidence on behalf of the respective parties have stated about their respective claim of possession. Then, Lord, on this ground, it has been decided against. So, Lord, entire this finding is also negating Exhibit 2 only on the basis of permission of Deputy Commissioner. It does not take into consideration Exhibit 2 for treating the date of possession, 61. It says 75, 30 years is not fulfilled, therefore that will not come into so far
This
as
is one is Exhibit 2, but so far as DW 2, 4 and 6 are concerned, the question of law is also related to DW 2, 4 and 6. What do you have to say to
but
that?
2, 4 and 6 they have not stated as such about any particular year of possession, but they have stated about possession. लेकिन ऐसा कोई possession क्योंकि it is a case of adverse possession, I have to cross that 30 years time prior to 99. That means 69 at least.
DW 2, 4 and 6.
2, 4 and 6. So 69 at least possession. तो ऐसा कहीं 69 का तो 69 कैसा कहीं
Trial court का DW 2, 4 and 6 का कहाँ reference है?
Yes.
We have read it yesterday.
But this is internal page 9 of the trial court judgment.
Internal page 9, yes.
But can I just show about internal page 8 first, because the trial court also records just before issue number 5 note. Hence even note just issue number 5 to note
Yes.
4th or 5th line. Hence even though by the deed of relinquishment no title passes to the plaintiff as the same is read by section 46 for want of prior permission of deputy commissioner, but the plaintiff could not be evicted from the suit land as the same is barred by limitation. Now let us see. Note issue number 5 notes adverse possession. Can we read?
Yes.
Adverse possession involves a mixed question of law and fact, and the same has to be considered on the basis of material adduced by both parties. Adverse possession means possession by a person holding the property on behalf of himself or on behalf of some person other than the true owner of having the right of minimum possession, provided the true owner is under disability or incapable of suing. Concrete proof of open and hostile and continuous possession is required in order to substantiate the claim of perfection of title by adverse possession. Now it has to be seen whether the plaintiff and the ancestor are in continuous possession of the suit land for more than statutory period, that is for 30 years, and whether the possession of the plaintiff was open and hostile. In this connection, the plaintiff has reduced oral evidence and have also put their reliance on documentary evidence. Now let us first discuss oral evidence of PW2. One of the plaintiff in this case has stated in his deposition that the suit land throughout remained in possession of the plaintiff and his ancestors. PW3, one of the independent witness at para 2 of his deposition, has also stated that the suit land is in possession of the plaintiff and prior to them their ancestors were in possession. PW5 in his deposition has stated that he plowed the suit land on behalf of the plaintiff. In cross-examination, this witness has also stated that he has never seen Musmat Parbatia plowing the suit land. PW 4 and 6 though admitted the position of the plaintiff but have stated that there was some period Muhammad Parvati has prolonged the suit line. PW 7 has stated regarding position of the plaintiff in his cross examination, he has stated that Muhammad Parvati has never prolonged the suit during her lifetime. PW 8, who belongs to the Khud to which the defendant belongs, has stated in his deposition that previously Jagat Narayan was the owner in possession of the suit land, and 32 years back he has executed a deed in favor of Ram. PW 9 and 10, who are plaintiffs in the case, have also supported their own case. So far as deposition of defendants are concerned, PW 1, one of the defendants of this case, has stated that during the lifetime of Parvatia, he did not claim the suit property. PW 2 is the wife of PW 1. In her deposition, the witness has stated that after death of Parvatia, she is cultivating the suit land. However, in cross-examination, the witness has stated that she has not seen any document pertaining to the suit land and she has no idea about the right title of the suit land. The witness has also expressed her inability in describing the boundary of the suit land. At para 18, the witness has stated that the plaintiff are plowing the suit land forcibly every year. As such, it appears that the witness of the defendant have also supported possession of the plaintiff over the suit land. PW 4 in his deposition at para 5 has stated that presently plaintiff has in possession of the suit land. At para 7, this witness has stated that plaintiff used to cultivate the suit land even during the lifetime of Parvatia. Again at para 14, this witness has stated that plaintiffs are in possession of the suit land since long. At para 15, the witness has stated that Muhammad Parvatia and Vishram never objected to the possession of the plaintiff. DW 5 in his deposition have supported the possession of the defendant and have stated that once he on behalf of the defendant have plowed the field with help of tractor. However, in cross examination, the witness has failed to narrate the boundary of the suit land and he has stated that he has not seen any document relating to the suit land and he cannot say how many plots of the suit land is comprised of. The witness have also stated that though he belonged to different village, the defendant Sahdev Bhagat is his grandfather. Lastly, DW 6 has stated in his deposition that Sahdev Bhagat is cultivating the suit land since last 7 years. Again at para 17, this witness has stated that after death of Muhammad Parvatia, Sahdev Bhagat is claiming over the same. From deposition of the plaintiff as well as defendant, it becomes clear that the plaintiff has in possession of the suit land since long. Now it has to be seen whether the plaintiff has in possession of the suit land, whether the plaintiff has in possession of the suit land for more than statutory period. Now let us examine, and then note exhibit 2 he considers and decreases.
So these oral evidences have not been considered
Yes.
by the appellate court. Appellate court
They have not
has,
dealt it at
they have
all.
not dealt with it. Appellate court has barely gone by the provisions of the
Section 46.
Photographic Tenancy Act. Yes, respondent. Is there any allegation against the allegation of collusion?
But there, I have stated in written statement. I start from the beginning. But the first of all, Your Honor, we kindly see the substantial question of law which has been framed by the Honorable Court. Well, may I read now? The substantial question was whether the learned lower appellate court has committed serious error in reversing the finding of the learned trial court in issue of adverse possession without considering the effect of Exhibit 2 coupled with the evidence of DW2, DW4, DW6 which were taken into consideration by the learned trial court for reasons for recording this finding. But my very first argument will be, since it's a main issue they have raised, that is a adverse possession. But the adverse possession is a question of law, a question of fact. But it cannot be a substantial question of law, so therefore this substantial question is not a substantial question in its true sense and legally also. Because the issue has been raised on adverse possession and it is a question of fact, and that too on the basis of Exhibit 2, which is a deed of relinquishment public surrender, which is which is quite a issue in view of the fact, because right from the beginning the provision statute says that any relinquishment or any transfer, it amounts to transfer. Admitted fact is that amounts to transfer in contravention of the provision laid down under section 46 without the permission of deputy commissioner is invalid and void ab initio. So therefore my learned friend has argued just few minutes ago, my lord, since it is a registered deed, even if it is a registered deed, since very inception and very statute says it is not permissible, so it is void ab initio, so no effect can be given with regard to Exhibit 2. And my lord, other aspect of the matter is, in the plaint, my lord, your lordship may kindly humbly take, I will humbly take your lordship to the plaint. My lord, the issue of adverse possession has to be specifically pleaded. They must be specific that from when they put on possession adverse to the title of that or real owner. But they have not given any date. Only they are harping on the point of deed of relinquishment, which have categorically denied in the WS. It is not the case. I have not denied. Your lordship may kindly see the plaint. My lord, relevant portion I will completely take your lordship to that. The plaint, my lord, they have taken the point of adverse position. Your lordship may kindly see. I will come to the judgment later on, my lord. First I am on the point of fact. The para 14, your lordship may kindly see. Para 13, 14. Para 13 I am reading of the plaint. Has your lordship? Para 13 of the plaint. The Salwa Mahato, the holder of the Khevat number 3/2, always remained in peaceful possession of the suit land and was continuing and exercising his right, title, interest and possession over the suit land till alive. After his death, his son Rama Mahato and Lachu Mahato, who were continuing and exercising their right, title, interest and possession over the suit land. And after death of Rama Mahato and Lachu Mahato, their sons, the plaintiff, are continuing and exercising their right, title, interest and possession over the same openly and adversely to the knowledge of the all concerned, including Sadeo Mahato and his legal heirs, successors and legal representative, and defect of title, if any, has also been perfected by their adverse position. So in the pleading, they have to, the rule of pleading is, my lord, that pleading must be specific. But here in this case, they have vague statement is given that they were coming in peaceful possession of property. From when? No date has been mentioned. Nothing. On what Supreme Court has said, on that point I will come to your lordship later on, but that the point of adverse possession has to be pleaded specifically and proved. And the burden is upon the plaintiff to prove the case from when they get in possession of the property. They have not so, they have not given anything, they have not substantiated. So therefore on this issue, my lord, learned appellate court has very well reasoned orders in past with regard to the adverse possession. Because there is no
para 14 also.
Para 14, my lord, yes, I know. That due to this reason, Jagat Mahato executed registered deed of relinquishment dated 28/1961 with respect to the suit land, relinquishing his right, title, interest and possession over the suit land in favor of Rama Mahato and Lachu Mahato. Then continue and confirm the right, title, interest and possession of the plaintiff over the suit land, and as such it is estoppel against the defendant now to deny the plaintiff right, title, interest and possession over the suit land. So they are harping on the point of deed of relinquishment. My lord, my reply may kindly be seen in the WS, my lord, what I have said so, because I have categorically denied that. I have denied to have executed any deed like this. And why they have created this reason, my lord, before institution of suit, I will come to your lordship. I will bring to your lordship that reason. I have denied, my lord, para 18 notes I will be permitted to read of my WS. In reply to para 10 of the plaint, the statements are not correct and denied. Jagat Mahato, Jagat Narayan Mahato, son of Sadeo Mahato, had never executed any deed of surrender in favor of plaintiffs within his knowledge. Despite of that, if the plaintiff are in possession of that deed, the same is illegal in contravention
Which
of
para are you reading?
para 118. I'm sorry, madam, para 18.
Para 18.
Para 18. So I have specifically denied. I have specifically denied that I have executed any deed of surrender like this. Illegal in contravention of section 46 of CNT Act, and why the plaintiff shall not derive any title by virtue of the void document. So this is just I argued before the Honorable Court. Any document which the statute prohibits cannot be given effect to in the law, in the eye of law. Further, my lord,
Jagat Mahato is not a defendant.
Jagat Mahato is not the defendant. My lord, their case is that.
No, you have stated in para number 18.
Yes, my lord.
Denied that Jagat Mahato,
Jagat Narayan Mahato has not the
son of Sadeo,
Sadeo Mahato.
right?
It is their case that Jagat Mahato has executed deed of relinquishment.
That's right.
Yes, which I have denied.
So which you have denied?
Yes.
That Jagat Mahato had not never executed any deed
Yes.
in favor of the plaintiff.
Must. Yes. And para 21, mother, that the statement para 20 of
And
21.
you are the descendant of Jagat Mahato.
Mother. And para 21, the statement.
Jagat Mahato, did he depose before the court?
Jagat Mahato. He has not been put on the witness box, mother. And para 21, it is also important that the statement made in para 13 of the plaint are not correct and denied. The claim of the possession is a repetition of claim. However, the suit land was in possession of Muhammad Parvatiya. She died on 1/10/1995. The claim of title by adverse possession is not correct and denied. The possession over the suit land is disputed since 1978. When an application for mutation was filed and same is disputed before the Anchal Adhikari Vardaka, during the present survey finally published in the year 1994. The record of right prepared in the name of Osman Purvatiya and the remark column possessed of the plaintiff is noted since year 1975. However, though not admitting the fact, despite that period of 30 years prescribed for adverse possession is not completed. Hence, question of title by adverse possession does not arise. The plaintiff may put to give specific evidence of the adverse possession. Thereafter, that the statement made in para 14 of the plaint are not correct and denied. The alleged deed of relinquishment dated 28/11/1961 is a void deed purported in contravention of section 46 CNT Act. It does not create any right, title, and interest of the plaintiff over the suit. And they are harping on this point only that if deed of relinquishment has been done, which I have denied categorically. And my lord, the genealogy of Russian mechanism, which is containing
Those rule है इसके अंदर.
जी जी 10 पुराना फाइल है मतलब सब कोई कम होगा जल्दी पढ़ते हैं
Full of dust.
जी जी इरिटेशन स्टार्ट हो जाता है
Master. How will I speak? How will I speak?
now,
Maybe this.
yes, my lord, I have genealogy I have annexed in para 9. It is part of the record, my lord, WS. Why they have created this problem, this suit? Why they are trying to make out the case on the basis of what? My lord, I am just submitting to you. Para 9. That genealogy, my lord, yes, Hathia Mato is a common ancestor, my lord. He has two sons, Sahadev Bhagat, alias Sahadev Bhagat, and Baja Mato, alias Baja Mato. Baja Mato, malad, we are belonging to Baja Mato. We belong from that line. Why he is because thereafter Sahadev Mato was succeeded by Jagat Narayan Mato, then Vishram Mato. Vishram Mato and the Parvatiya was the wife of Vishram Mato. Sahadev Narayan Bhagat, malad, Vishram Mato predeceased Jagat Narayan Mato. So Parvatiya came in picture, and since as per the Unnao customary law of inheritance, since the woman doesn't inherit any property, so therefore they have created this right. They have created a case. They belong to, they all of it, this line closed, my lord. So this is the exact judgment passed by the Honorable Appellate Court, the learned Appellate Court, that this line closed after death of Parvatiya. And that too on the basis of a void deed of a relinquishment. They are harping on the point of void
Deed of relinquishment has been executed by
Jagat Narayan Mato. Their case is that. It is their case, not our case. They may put to strict proof of that, to prove that, because it is duty of the plaintiff to prove his case, not the defendant.
So what about the right of Vaishnav? This
Baja Mato, we belong to that family, defender of one. In the last portion, I have written that defender of one.
so therefore the property would devolve on this
Sahadev.
Sahadev.
Yes, after death of Parvatiya.
After death of
And
Parvatiya.
yes, and rightly devolved in the
And Sahadev Bhagat is not a party to the exhibit.
yes.
Sahadev Bhagat is not party to exhibit.
Yes. Sahadev Bhagat, my lord, he is a defendant of one.
He is not party to exhibit.
Party to?
Exhibit 2.
No, certainly no. He is not party. It's their case. Jagat Narayan Mahato has
The
exhibited.
land is recorded in the name of Sahadev Bhagat.
Yes.
And not in the name of Hathiyaman.
Yes. So property automatically after death of Parvatiya devolved in the share of Sahadev Bhagat, which we belong to.
Parvatiya died in 1995.
1995. Date is also given, 1985. So after death of Parvatiya, line closed 1/10/1985. Parvatiya died on 1/10/1985. Para 21 of my WS. And the judgment, my lord, thus my learned friend has cited that regards to restoration of land under section 971 of the CNT Act. That lays down the provision that the restoration of land can be done any time for the with the knowledge of Deputy Commissioner, but it should be within reasonable. This is the judgment of Situ Sahu, Kulchan Munda, and Jayamangal Uram. So therefore, this was not the issue for this neither the learned trial court nor the honorable appellate court. This was not the issue. And in the second appeal, my lord, only the argument has to be advanced on the basis of on the basis of substantive question of law frame. My learned friend cannot divert that. So citation and judgments which was held by with regard to different context. Here is the case that section 46, whether the deed of relinquishment was valid or not, it was not valid because statutes prohibit so. And they are harping on that point. Number two, point of adverse position, they have not pleaded specifically. In the plaint also, I have denied also, they have not pleaded specifically. And the Honorable Apex Court has rightly pointed out and held that your Lordship may kindly, at the cost of repetition, I may humbly take your Lordship to the Honorable Appellate Court judgment. How Honorable Appellate Court has dealt with regard to point of adverse position.
We have read it fully. What do you want to say?
Yes,
कल से आज तक 2 बार पढ़.
हाँ ठीक, तब ठीक. मतलब just I wanted to insert.
एक बार हम घर में भी पढ़ लें.
जी.
3 बार पढ़.
So these are the main points, my lord. And on the point of other question, I may be permitted to cite the judgment that Honorable Supreme Court, my lord, your Lordship may kindly have the copy of this. Para 11 is important, my lord. Entire para 11. Plea of adverse possession has been taken vaguely in the plaint. Para 11. Yes. Plea of adverse possession had been taken vaguely in the plaint. No categorical stand on this point was taken in the plaint. No issue has been framed, and seemingly the same was not insisted upon the plaintiff respondent. Adverse possession is a question of fact, which has to be specifically pleaded and proved. And they have even if they have pleaded but not proved, because they have not given any specific date from where they have put to possession adverse to the title of the order.
You see, if a person says that I am in possession since 1905.
Yes.
And then he is not able to prove his possession since 1905. But there are certain documents or materials to prove that he is in possession since 1947. Then his plea of adverse possession will be rejected on that ground.
No, on that ground it can be rejected. But here in this case, but they rely on the deed of relinquishment. That is
no, they say that they were always in possession, and then a deed of relinquishment was executed, and in the deed of relinquishment, their possession was acknowledged. And there are further cases that there is no allegation of collusion. The appellate court has only taken into consideration section 46, and since the deed of relinquishment was against the statute, and therefore the appellate court has rejected the plea of possession at least from 1961.
yes. Yes.
There are further cases that in case there is no allegation of collusion or fraud,
Yes.
then under such circumstances, there is a presumption in connection with execution of registered document. Whenever a document is executed, maybe that the contents of the documents may require some proof, but so far as execution is concerned, that cannot be disputed. So you cannot say merely by stating in the written statement that he had not executed. You cannot say that this particular and the person from the registry office had also come and deposed before the court. He brought the register and then he proved that yes, it was executed by the same person.
Yes.
So execution of deed of relinquishment is not in dispute,
Yes.
but its legality, validity,
Yes.
and its admissibility as evidence,
Yes.
so far as title is concerned or possession is concerned, that is.
Yes. And this was the point.
So therefore, the judgments which he has cited by the Honorable Supreme Court, it has also taken into consideration section 69, this regulation 69, and it has said that merely because the transaction is fraudulent, You cannot say that the possession cannot be recognized on the basis of such fraudulent transaction. Here, the fraud is only against the statute and nothing more.
Yes.
There is no inter-party fraud.
Yes, yes.
The
That
fraud is
the,
only against
yes,
the statute.
yes, yes. That is the crux of the matter also.
That is the crux
Crux
of the matter.
because he has confined his argument also. On
Confined, and that is the case also.
Yes, that is the case also.
Therefore, their possession with respect to the property since 1961, how do you discard it? And this presumption in connection with record of rights since 1975,
Yes.
right? This particular document has only a presumptive value and nothing more.
Yes.
Then, what case do you have? The appellate court does not discuss any evidence. The appellate court assumes that it is violative of section 46
46.
and therefore that cannot be seen at all. This is it. So how do you justify the appellate court?
Well, since the appellate court has given finding on the point of that validity of the section 46, the Lordship may kindly see the provision laid down in section 46 of the CLT Act.
Listen, we don't need to read it
And
time and again.
yes, Lord, but
What do you want to emphasize?
Yes,
We have read
yes.
it many times.
Malad, then Malad, one judgment of the Honorable Patna High Court, Malad, I am trying to point out. Yes,
The CP solve on the judgment. एक और judgment. 2003 का 7 SCC land.
Malad, the judgment passed by the Honorable Patna High Court, Your Lordship, may kindly see. It is on the point of section 46. Malad. Yes. Honorable Patna High Court judgment, para 4, on the point of section 46. All the three courts below rejected the claim of petitioner and held that if post prior permission of the Deputy Commissioner was necessary before the plots in question were surrendered in 1951, it was not explained by the petitioner as to how one of the plots, namely plot number 1640, was surrendered twice, both in the 1940 and 1951. Admittedly, the settlement was made within 3 months of the surrender. The permission of the Deputy Commissioner was also not obtained in 1951. These findings of the fact are conclusive and no infirmity has been pointed out to dislodge the concurrent finding of the fact. In fact of the case, admittedly, his plots out of 16 plots were surrendered in 1951. Plot number 1640 was also resurrendered in 1951. The surrender of the plot number 1640 made twice in the 1940 and 1951. In the absence of any explanation whatever makes the transition lawful, the petitioner has failed to submit any explanation. The entire land was surrendered in 1951. Plot number 1640 was also resurrendered without obtaining the permission of Deputy Commissioner, as required under section 46 of the Act. Thus, the main object behind the surrender and settlement of land was to bypass the statutory provision of section 46 of the Act. Therefore, the transaction becomes intrinsically invalid. It is well settled that the policy of the Act is not to be defeated by an ingenious device. The policy of the legislature is enacting section 46 of the Act is to secure to tenants inhabiting the area to which the Sharnaku tenancy applies their right to their occupancy holding and to protect them on the facts. Undoubtedly, the device was circumvent and bypassed the statutory provisions of section 64 of the Act. The transaction was therefore invalid. Judicial recognition of the fraudulent contravention of section 46 of the Act cannot be granted. No other points was raised for the consideration. So with regard to section 46, my lord, and my lord, it is a settled law passed by the Honorable Supreme Court on this Honorable Court also, that the plaintiff has to prove its case. In this case, my lord, they have taken the point of adverse possession, but they have not proved it. This is my respectful submission, your lordship. On that issue, my lord, Honorable Supreme Court has given a judgment that a plaintiff has to prove his case specifically, and the point of adverse possession has to be pleaded.
Which
Just
ingredient of adverse possession has gone in?
ingredient, my
There
lord,
are various ingredients. Which ingredient has gone in?
it has to be some specific date has to be mentioned.
No specific date.
No specific date, because from where they are put to possession, or they simply say they were continuously in possession.
No specific.
No specific date.
Then
Then, my lord, this judgment, my lord, plaintiff has to, and since they have make out a case of adverse possession, so it is duty bound. They are duty bound to prove its case, my lord, as per the judgment of the Supreme Court. And they
करने से कुछ ज्यादा इम्पैक्ट नहीं होगा.
अच्छा ठीक.
आप हमको ये बताइए एडवर्स पोजीशन क्लेम करने
जी.
के लिए व्हाट आर द बेसिक इंग्रेडिएंट्स व्हिच आर रिक्वायर्ड टू बी प्लीडेड एंड प्रूव्ड
Yes.
एंड व्हिच एलिमेंट दे आर नॉट.
Yes. Main ingredient is that, my lord, they must be specific that when they put in possession, adverse to the title of the original order, they have not given this.
61 is there.
61 is there. It is invalid document as per the law.
That's
Yes.
But their case is 61.
61, their case is that which has been denied by in the WS. So they cannot get any right from the invalid document which law doesn't provides. And another judgment, my lord, on the point of the plaintiff has to prove its case, since whatever they have make out the case, they have to prove. My lord, this judgment is 2019, my lord. One copy, para 17-18.
2019.
2019 relevant
2019 what?
19 volume 11 SEC page 309 para 17 and 18 para 17 and 18 just to demolish their argument that they have proved his case. Para 17 the plaintiff the plaintiff has to prove his case to the satisfaction of the court. He cannot succeed on the weakness of the case of the defendant. Even otherwise, there is no conclusion at all regarding the identity of the property in question. On the basis of material on record, the first appellate court has correctly ruled that the appellant of the defendant 1 has proved his title possession over the suit property since the date of his purchase of the property. Prior to the purchase, his predecessor in interest was in possession of the same. Having regard to the position of having regard to the position of law and fact of the case, we are of the considered opinion that the High Court was not justified in interfering with the judgment of the First Appellate Court, which has come down very heavily on the procedure adopted by the trial judge in deciding the matter, more particularly when no court can be found on the fact with the judgment of the First Appellate Court. Generally, it is not open to the High Court to interfere with the finding of fact recorded by the First Appellate Court when such findings are based on the evidence of record and are not perverse or against the material on record.
That's all.
That's all.
You have to say anything in the book.
But so far as they have stated, argued not that there is no pleading. The Lordship may kindly make a note about paragraph 10, 13 and 14 of the plaint.
I said not prove.
हाँ,
Pleading तो है. Prove, prove.
भैया बोले ना प्लीड नहीं किया है,
Plead and prove.
हाँ तो बता रहे.
प्लीडिंग तो मान ले ना. प्लीडिंग इज देयर, ये तो मान ले.
हाँ, pleading मान लिया, बोले तो. अरे
Reading मान लिया।
reading मान लिया।
Note anyways, note. Para 10, 13, 14, and in reply paragraph 21 and 22 of the term notice, in which
10, 13.
10, 13, 14 of the plaint, and reply notes paragraph 21 and 22 of the WS. So it is not a adverse possession was not. Now notes the Patna High Court judgment which he referred, but the facts are completely different what I heard. But so far as the Supreme Court judgment which he has just now referred to, that the plaintiff has to prove his own case and the High Court should not interfere. But that judgment perhaps notes in paragraph 19 what he placed supports my case because the appellate court does not consider at all the evidence of the parties. And therefore the Lordship has already noted my argument that there is no case of the defendant that any fraud have been played. There is no case pleaded by. The only case with regard to Exhibit 2 is that it was not within my knowledge. First line. Second is it is in violation of Section 46. No case pleaded of fraud and no suit have been filed. Once they got to knowledge of Exhibit 2 notes in the suit, they have never challenged that. Their conduct also shows that they have not challenged this Exhibit 2. And we have specifically pleaded about adverse possession. We have taken this. Right.
दूसरे कोर्ट में मत जाइएगा आपके सबमिशन में यस आई एम टेकिंग
Yes, yes, अभी बेल चल रहा है.
जो काम किए हैं उसको कंप्लीट करिए 99 का केस है कोविड में भी हम कभी मास्क नहीं लगाए तो